This is week 2, module 4, and we'll be covering the power of appointment. By this time in your readings in the textbook and my discussions on board here, you found, I'm sure, terms that you're not familiar with, or it's being used different than you've heard it being used before. I really recommend you look at the dictionary that we put into the introductory portion, which covers the dictionary of terms used in estate planning. And I also recommend that you print it out so that you can use it throughout the course. As you can see here, power appointments cartoon shows someone having power over another, and that is definitely true, because the purpose of a power appointment is to allow someone to control the assets that they don't own. You say, how does that happen? Well, it happens quite often. I think the hardest part about power of appointment, which we're going to discuss, is that in real life, in the real world, including exams, we don't call it a power appointment. We just say, John has been appointed the right to control the assets of the family members. Well, if John's in the family, or if he isn't in the family, it doesn't matter. He has a power appointment. He's controlling the assets of someone else. So we're going to be looking at this and realize when we're going through here that, yes, indeed, in the presentation and in your textbook, you're going to see the term power of appointment. But in real life, you're probably not going to see the term used. Some lawyers do use it in wills and trust, others don't. But again, we go by substance, not form. So if it's a power over someone else's assets, that's a power of appointment. Let's look at the definition to begin with. First, it's a power to control assets of another person, and that we've been telling you that for the last minute or two. And it also allows the individual who has the power to determine who can possess and enjoy the assets, which is, to me, the same as owning the assets, and to the law, the courts, and for taxation purposes, it is the same as in owning the assets in many cases. The executors and trustees are good examples of individuals holding these powers. And I might note that if you have a trustee or an executor who is a family member, it is probably a taxable event for them. And if they are not a family member, such as a bank or a trust company, or a professional executor, they probably still have the power to control, although they don't benefit personally. Parties to a power of appointment, we have the donor, creates the power, and is an owner of the assets. And we have the power holder, who is one who controls the possession and use of the assets. And again, this is typically done under a will or done under a trust, and sometimes under a power of attorney, being the most common types. And those receiving the benefits of the power of appointment are called beneficiaries. And unlike a trust, which very rarely has the trustee also being a beneficiary because of tax consequences, under a power appointment, it is common that the person who has the power is also going to be a beneficiary. You say, Lee, that's inconsistent. You just said trust. It shouldn't. Power appointment, it does. Well, again, if things were perfect, trustees would not have power appointments that benefit themselves, but we will get into that as we go along. General power appointment is the one that's probably most known and heard. It's the power to exercise power for your own benefit, for the benefit of your creditors or holders' estate. Now again, the will might say, or the trust, that John, being my oldest child, is responsible for determining who in the family is to get the income this year and in subsequent years. Well, John is a member of the family, so he can benefit because he could pick himself to get it. And therefore he could benefit, or if his creditors can benefit, or his estate can benefit. And so even though it doesn't call out for him to benefit, he would have a general power appointment, which is important for tax purposes as we get into weeks 3 and 4. A special power of appointment is when the holder of a power cannot exercise it for the benefit of themselves, their creditors, estates. For example, this would be a bank or a trust company who are administering for a decedent or for a trustee. I'm sorry, for a trustor. And that exclude them. Or it might be one where I figure my kids are not as good with money, so I have my son-in-law being the holder of the power to exercise for the benefit of my children. Well, he's not my child, so he would have a special power, even though he's married to one of my children. It doesn't matter, he still has special power. An exception is made if the holder of the power can benefit and be exercised in holder's favor only with the consent of the grantor or having a substantial adverse interest in the property. So if the trustee was in the position where they had to get, under the terms of the trust, the permission of the grantor before they released the money. In other words, the grantor retained the right to approve it, then it would not be a special, like general power appointment, even though they could benefit. Or where the beneficiaries get to determine with you as the grantor, the trustee who is the going to receive the assets. Now, it gets a little confusing because if the grantor has that right, that is actually a grantor trust, which we'll be talking about later, and has tax ramifications, but it does happen. And a lot of grantors don't like to give up controls. And likewise, it might sound strange that the beneficiaries have to agree with the trustee. Well, is that taking away the power from the trustee? Yes, but what it does is it prevents it from being a general power of appointment. There are other ways of avoiding it under the tax laws. There's no tax ramifications. The agreement providing for the power has a holder having a general power appointment has either an ascertainable standard, which is health, education, maintenance, support, as discussed in your textbook, or what's called a 5x5 power, which is that they have a right to taking out 5% or $5,000 a year, and that means if the amount paid out or they can be taken out is 100,000 unless it's 5,000. If it's more than 100,000, it's 5%. If these are found with a general power of appointment, then you don't have a tax problem. So it is advisable, and I'm sure attorneys, if they're involved, arrange that any general power of appointment has an ascertainable standard or 5x5 power with it. The only time I can think of where you would not grant this or put this restrictions on general power of appointment is what's called an A trust, which we cover in week 4. Other than that, and we'll give you an example, John is the oldest child, and as such I want John to be responsible for making payments as needed to the family members of income each year, and John has an ascertainable standard. Well, by giving him an ascertainable standard, he does not hold a taxable general power of appointment. Or I could have John being able to take out 5% of the value of the assets each year. Again, that would prevent him from having a taxable event. Consequences of having a general power of appointment without the ascertainable standard or 5x5 power, or the approval of the grantor, or the approval of adverse parties, results in making a transfer to the beneficiary being a taxable gift made to that person. If you release the power, it is deemed a gift as the power goes to another, and it's the full value of the assets. Failure to exercise the power and the power lapses or terminates is a taxable gift, or dies when holding the power results in the value of the assets going directly into the estate. In other words, it is bad tax-wise if you hold a general power of appointment without having the ascertainable standard, the 5x5 power, or an adverse party rule like we talked about, or the grantor control. Therefore, only you want to see this in an A-type trust. Any other situation, you wouldn't want to have it. Grant GPAs are not always obvious. Um, Remember, we go by substance, not form, when we deal with taxes. And the holder has a power. It's a GPA or a special power appointment, irrespective of what it is called. And that could be a trustee, it could be a personal rep, it could be an agent. Doesn't matter what we call them, if they have the power to determine who can receive the assets or receive the benefits of another person, it is a general power appointment or a special power appointment. Again, determining on does the general power, if you have the power to use it yourself, your creditors can benefit or your estate can benefit. And again, we are at the end of the session, and we will be asking you to look at the next module at your earliest convenience as we attempt to turn off this particular version.